That's
We're on.
Okay, I'd like to welcome everybody to the New York State Board of Elections meeting. I am Peter Kusinski, co-chair of the board. To my right is Doug Kellner. The other co-chair to my left is Greg Peterson, the commissioner, and Andrew Spano. On my far right, the other commissioner. The first order of business today is certification of the results of the April 19th, 2016 special election. There were contests in Senate District 9 and 3 Assembly Districts, 59, 62, and 65. So this Board of Commissioners will certify those results.
Okay.
I guess we need to sign the certification.
we need a motion.
I so move that we approve the certifications as submitted.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Opposed? It's carried.
So, there are 3 of them or 2?
There's
The Assembly, 1 Senate.
Oh, I see. So we're signing
2 separate.
one for the Senate. Right.
Right.
Pass me that one when you get chance.
This one, who did this?
Bless you.
Andy.
You have all 4.
This one, this one. That one doesn't have the red folder.
That's it? Okay, with that completed, we can open up the meeting of the regular Board of Elections Commissioners. First order of business is the minutes of April 5th, 2016. Proposed minutes are in front of us. Is there a motion to accept?
Motion to accept.
Second? All in favor?
Aye.
Opposed? Those are approved. And separately, we have the confidential minutes of April 5th, 2016. I would entertain a motion to adopt those as well.
Move.
Second?
Second.
All in favor?
Aye.
Opposed? Those are also carried. Okay, then we'll move into unit updates. Our first unit is the executive unit, Bob Brem and Todd Valentine.
We've been primarily focused upon what's coming up later in the meeting on the objections for Congress. All the petitions were filed, and then the objections were filed after that. In addition, we did have the presidential primary was in the middle of that. We expect the results from the county to be certified for us at the end of this week is the deadline for them. And then we'll transmit that to the parties, and then they in turn send it out to the delegates from there. And then, looking forward, then we'll transition to the congressional primary is in June 28th. But prior to that, petitions will also start getting circulated for the September primary. So it's a question of fielding calls from the 3 different elections and inquiries, all kind of at the same time. So we've been busy.
Bob, you need
I think certainly with this special, the petition challenges, everybody in the agencies worked hard to work the specs and to hold hearings. We've had a lot of cooperation from a lot of people, very long hours to get the report for you today. And certainly we never make anyone happy when we work specs because somebody is going to not make it on the ballot, but that's the process. So it's been a very long hours. I think people have, we put hours in, staff coming in at 8 in the morning until about 9 at night in order to get it done for the last 2 weeks in between the special election and the primary. So it's been extremely busy. We also completed the required internal control certification to file that with, to make our certification that it is complete. And myself, I had the benefit on primary day to go out into Nassau County. I was down for the special area just to look whenever you put a special and a primary on the same day in the same spot. The last time they did that was in Oneida County for that assembly district, and they opened at different hours of the day. That was even more interesting. So I went there to observe that in Oneida, and I also went to Nassau County, and you could see the work that the commissioners and the staff did there to train, brought everybody in for training, because they had wherever I went, I started in Long Beach and worked my way to Elmont, and then came back here for the close of the day. But everywhere, they had a good plan to make sure that the people who voted on everything were closest to the door, and then if they were eligible for the next part, they had to go to the, once they finished the special election, go to the primary election for president. So they really had, you could tell they had a relatively well, they knew what was required, the staff, and I thought it worked well. So I was pleased to see that. Certainly it was crowded in some of those polling sites to have the extra tables, workers, staff in there. But they were all very busy when I was there, and I thought the commissioners and the staff did a great job pulling it off. So I just want to let you know that.
Okay.
I think that kind of covers most of our information.
Okay. Any questions? All right, then the next unit is the council compliance unit. That's Kim and Brian.
Thanks, Commissioner. Well, what they said, basically you've been all very busy monitoring and working the specs. It's interesting because we have 9 ballot access cases that were filed, 7 of which are still active. And just for some people listening, what we have to do is get the petitions, the specs, work the specs, get the hearing all before the court date usually, so that the court can make a decision. So that's a coordination effort that seemed to work out fairly well. 2 of those 9 have since withdrawn or ended those cases. Brian and Bill, we had a lot of new staff that came on since the last one, trained them on doing the specs and working the specs, so it was a new endeavor for a lot of the staff people, which was interesting. They thought they were all excited until they started to do it. We anticipate we'll have some more litigation following today's meeting, as you have 3 days to bring a validating proceeding. I think that's taken up most of our time, except for the fact that we worked on finalizing the rest of the things on the agenda, such as the FOIL document and confirming the IE regs were ready and some other stuff. Right? Do you have anything to add?
That pretty much reflects the bulk of the things that have occupied the unit's time. I would just want to mention that we did conduct 2 club trainings on April 6th and 7th in New York City and on Long Island. Work to finalize the handbook is continuing, and let's see. I think those are the main points. And there are 4 federal lawsuits related, 3 federal lawsuits related to the, in some manner or another, the April 19th primary that have been worked on very, very well by our colleagues in the Attorney General's office. We continue to work with them on those, all 3 of which are open in some manner or shape or form.
Okay, any questions for council? All right, then our next is election operations. Anna Savitsro.
Thank you, Commissioners. Brendan and I are happy to be here. I'm sorry that I did miss the last board meeting. We have been doing everything that everybody else has said. We've been working on specs, working on reports for this meeting, like pre-election, election day support, complaint resolution regarding the presidential primary. We facilitated the ballot access filings. We received, acknowledged, and prepared all the correspondence related to 113 petitions, 62 acceptances, 54 authorizations, a number of declinations, substitutions, 67 sets of objections were received, 26 sets of specifications were filed. So a number of those objections do fall by the wayside. We prepared the documents for your Board of Canvassers meeting for today, and we'll be preparing presidential results for the two state committees once all of those have been received. We've also collected local filer information for the congressional contests that file locally, not here at the state board, so that we can have a complete candidate list. We'll also be following up on any litigation or board determinations related to those filings locally. I believe we have 13 primaries so far. I'm not sure that any of the litigation at the local level or determinations yet to be made at the local level will affect the number of primaries in the state. But we can get you a new number once we have all the county board in hand. We continue to work with IT on the campus system. We did get approval to attend a conference on voting systems at MIT. It's going to be held in June 20th and 21st. Brendan will be going with Charles Smith from our staff and also Rob Zeglin from Nysboe. Commissioner Kellner has been asked to speak at that session. Brendan, we don't want to put Brendan right into the fire, so Brendan's going to introduce everyone else. We have some papers that we're going to present, our certification procedure, in which a number of the attendees have expressed an interest. This conference is usually held on the West Coast in Portland or places like that, and travel has been prohibitive for us. So we'll be providing our reports to them, reviewing our procedure with them. Rob Zeglin from Nysboe is the lead security consultant for our certification, so he would be a good speaker to explain how our process works. And it gives us a chance to network with, for our guys to network with people who do what we do all around the country. We right now are at a loss for reaching out to people who sort of speak the same language, so we're hoping that Brendan and Charles and unfortunately Bob Warren can't make it, neither can John Ferry. So we're hoping to beef up our bench strength when it comes to reaching out and talking about these issues with other states. The EAC is going to have their representatives there as well, Brian Hancock, and Brian has a new deputy. So that'll be a good opportunity for everyone to meet everyone. And we're just happy to be able to go to the park, so to speak. Brendan, did you want to add anything?
No, I think everything's on the sheet if there's anything else.
Any
Any questions of elections? No. Okay, thank you, Anna.
Thank
Next is the NVRA PIO. John?
Good afternoon, Commissioners. Public Information Office was extremely busy over the past few weeks, particularly on the presidential primary day. We had 6 people manning the phones in the Public Information Office, and they were busy from the beginning of the day to the end of the day. Pretty much as soon as you finished with one phone call, there was another one ready to go. I don't have a specific number, but I'm sure it was close to 1,500 calls we probably got that day. I mean, it was things from, you know, am I registered? Where am I registered? Where's my poll site? You know, the ordinary kind of things, the occasional, the machine's not working at my poll site, or the poll site's not open yet, or things like that. It was fairly routine. We probably had close to 700 emails, again, similar kinds of things. Approximately 121 of them were what I would consider complaints. 60 of them were from around the state, 61 of them were from New York City, which we've attempted to address. So we had a lot to do in that period of time. Since that, and with all the congressional petitions and the objections and the hearings and that stuff, we've continued to be extremely busy as everybody has called and asked questions about those materials. We had 109 FOIL requests in April, which was a significant jump, almost a doubling from the month before. I attribute that to the congressional petitions. We participated in the monthly ECA call on the 28th. Tom sent out a reminder on the MOVAC surveys for the presidential primary and the upcoming June primary. We posted a list of filings on the website for the federal primary petitions. The notices for the April 21st and May 20th campaign finance compliance webinars, the webcast for April 5th, and the transcripts from March 24th and April 5th are also posted. In light of the voter registration deadline on March 25th, we had a couple of complaints from the local counties about DMV not being aware of the deadline or getting them some materials in time from Orange and Seneca counties. Orange had said that their local DMV people were not aware of the registration deadline, and Seneca had a package of applications that arrived the day after March 30th from the Ithaca DMV office. We confirmed that DMV received our reminder about the notice from Greg back at the end of February. We also discussed this with DMV in our meeting. They assured us that it was included in their mailbag communications that goes out to all the DMV offices. But the next notice that will be for the June primary, which is the deadline is June 3rd, the registration deadline is June 3rd. We've slightly altered the wording in it to emphasize that the registrations have to be sent in such a way that they arrive at the intended Board of Elections no later than that Wednesday following the Friday deadline. So that's all I have. Do you have anything to add, Tom?
The only other things I would add is with regard to the elections. Obviously, we did election night results on election day, so I want to, thank everyone from both election ops and IT who helped make sure that went smoothly on election night. As John mentioned, we have the surveys that went out for the presidential primary with regard to the military and overseas voters, and I'll be sending out, as I told all the counties on the ECA call, the next batch of surveys for the federal primary. And the last thing that we're working on right now, which we're going to do next week, is we run our NCOA lists, just because the counties have to send out their notices in August, and so we run our voter database through the NCOA database now, so that they have they need CAST certification. It's a 90-day window where they can get discounted rates on postage. So we're going to be running our voter list through that, and then we'll be providing each county with the results of that kind of NCOA scrub. But beyond that, I think that largely covers everything we've been doing.
I have a hypothetical question.
Sure.
If you had 3 primaries folded into one day rather than 3 days, would that make your situation untenable in terms of what you had to answer, what you had to fulfill, et cetera, et cetera? Or would the work be the same?
Well, I mean, there's a lot of overlap, but I mean, obviously, depending on what primaries you're having, I mean, the more parties that have primaries and the different types of offices, there might be some, different questions that you're answering. As we also had a lot of questions, there was some misinformation that we were trying to combat with regard to difference in polling hours. People thinking that it was a new set of hours for the primary, when in fact it's been that way for a long, long time. But I mean, it would probably just increase the amount. I mean, the type of work is the same, but I mean, the volume would probably certainly increase.
That's my question. Could you handle a volume that would double? Or is it easier having primaries spread out like this or elections spread out like this?
Well, it's not easy.
It's easier.
I mean, certainly.
Easier.
Easier in one way.
The calendar that we have that Judge Sharp has ordered for the June calendar was something that we had recommended, only the basic things that needed to be changed because we were asking the federal judge to supersede state law. Certainly, I think the proposal that before the Senate and the Assembly, that while they have different dates, I think all of the windows are almost worded exactly the same. That gives more time Because if we were to receive specifications and objections for all the petitions at one time, Senate, Assembly, Congress, Supreme Court, all of them, we would need a little bit more time than we have now to get it done. I mean, as it, you know, so it provides a little bit more time in that calendar. So should that, one of those bills pass, I think we would be better able to do a uniform primary, because it gives us a little more time to actually do the you know, get all the objections, work the specs, hold a hearing that can at least be meaningful, so that we're not just going into litigation because we couldn't finish in time. So I certainly think there'd be a lot of benefit to uniform primary. We would certainly gear for it a little bit differently. I think we should make our own list of issues after this learning event of the, you know, we have not had a competitive statewide presidential primary for Democrat and Republican, really competitive, because usually by the time they get to New York, we have a primary, but it's kind of already a foregone conclusion. So that was busy enough, and then all of the people that tried to promote the open primary agenda also directed a lot of resources, because they were telling everybody, yeah, I know that you, but do it anyway. So we were getting an awful lot of complaints to everybody, all the whole building. You know, we could see social media, we could see the reports, yeah, that's what it's, but just scream loud and demand it. So if you look at the number of court orders that were issued, I don't think it's a lot different. If you look at the affidavits, they're way up this year, but I don't believe, but they're mostly not valid because it's the people who said, we'll go do it anyway and sue. So there are a lot more resources that had to go to that kind of effort. But I think certainly we would want more phoners within that last 2 weeks to handle
If you had a unified.
than we had, because you could not get anything else done in the building, because whether it's enforcement, PIO, the phones were ringing everywhere, and people were calling us, and you had to respond to them. So certainly we would probably bring in some 10 people and gear up just to handle that. But if it were not if it were one party, if it wasn't you know, this is like a once in a 30-year issue. If we had them all on one day, I would bring in more temp workers for that, to cover that, because it would be busy. But I think we could handle it.
And
But right now, we're working it for the whole year.
Overall cost would diminish?
I think the overall cost of the state would diminish because of all of the primary days and workers and, you know, if the poll site's open. I mean, look, we had statewide Democrat and Republican. You're not adding that many more for all of the other parties. Every polling site had to be open. Every worker had to be there. So from a human resource and poll site, there's not much, the only added cost would be the ballots you'd have to print for those other political parties that are having a primary. So certainly one primary unified would be much easier for us to plan.
You want to opine on why we don't have one primary?
Well, we don't seem to agree on a date.
Thank you.
Okay. Commissioner.
Oh, sorry.
Could you tell us what the state board is doing with respect to the various investigations going on now about the reports of registration cancellations in Kings County?
What I can speak to is that I know that we've been looking at the information that we have on our end as far as the transactional records that we've received from New York City and Kings County specifically. I think that we still need to try to have our IT people talk with their IT people to try to understand what processes are in place or are not in place or that should be in place, because from what we can tell, you know, we don't seem to agree on, you know, I believe they believe that they sent us a whole bunch of information last year with regard to some of these voters who were purged. But as far as we can tell from our records, we did not receive nor reject any transactions. We did receive them all in February, and so I think that we can account for all the different transactions. I think that there's a discrepancy in understanding when they were initially sent or resent or whatnot. And so I think that's what we're trying to figure out now.
And why Kings as opposed to the other 4 boroughs?
Well, I think that we see, I mean, I can't speak to why Kings, specifically. I think we did see some consistency between all the different boroughs with regard to certain, I'll call them lag times in transactions being sent to us. And I don't know if that's just because of the process that all the different borough offices work before they send us transactions for purge voters. But I don't know why Kings as a single borough had, let's say a statistically significant more higher number of purge voters than the other boroughs.
And are we participating in any of the ongoing investigations besides what you've reported on?
I mean, to my knowledge, all that we've been trying to do is getting an understanding of what's been happening on our end, so that we can kind of fill in whatever gaps we can, but obviously we're only the recipient.
And you're doing that coordinating with the city board IT staff?
Yeah, I mean, at this point, we have not had a meeting between our IT department and their IT department. I believe my understanding is that is the intent, so that we can make sure we have, on both sides, have a full understanding of what actually transpired and how to make sure that it works as it should going forward.
Commissioner, I think I can also answer that. I've been in contact with the Attorney General's office, and we are, at this point, sharing information as to the complaints that I've received and the complaints that they've received.
I think from our point of view, we've talked to the city board and trying to get their time to finish their certification, as well as us to do the petitions, but to look as quickly once we certify the presidential primary and certify the candidates for the June primary, which the deadline is tomorrow, to then, whether it's by a conference call or a visit to the city board, the 2 issues. In general, the computer issues that that Tom described that need a fuller conversation to understand what is being claimed and what we can see through the electronic logs that are kept. And the second issue, I think most importantly in New York City and in Kings County, was the procedures that were used by the staff to make decisions on who to purge or not. Because it's my understanding from what I've read, and I think in some of what I've heard, but I don't have all of the parts yet, is that the statement is that that they're going to reinstate certain people that were purged inappropriately. So we need to review with them to make sure that there's a complete understanding under NVRA, Help America Vote Act, and the state statute as to what are the proper procedures in place and where did that go wrong, if it went wrong, to make sure that everybody is trained on what are the proper list maintenance requirements, and that they at least have an internal control to verify that those steps. And it could be they understand the steps, but something went wrong in their internal control, but I don't know enough yet. But certainly, we would want to make sure that we all walk away from these are the correct procedures to use, and then going forward, that's what will be used. But that stuff hasn't happened yet because of all the time to
Because
get
we
to
had certification and petitions. But, so it's my understanding, though, that we will be working with the city board and with Controller Springer and the Attorney General to work through the investigation to figure out what went wrong, if anything.
Well, we have not been contacted by any other agency other than the city board, so they have not reached out to us. So, I mean, this is the first I'm hearing that they've spoken with RISA, so I'm not otherwise aware of that.
I mean, up to Election Day, any of, and I know RISA, any concerns that voters sent to enforcement that weren't necessarily an enforcement, but more of my record needed to be checked. We followed up on those that she sent to us, whether it was New York City or not, and tried the best we could, at least up to Election Day, It was hard for me to do that for the ones that came late in the day on election day, but certainly we were able to help people correct the record. Many instances, people were misunderstood of what their enrollment was. But certainly anything we received, whether it came from enforcement or the phones or PI or anywhere, our first goal was to look up the record and try and get people useful information. When it was no longer possible to get the record straight to be in a poll book, then it was, is it an issue that they should, that the board made the correction, but if the poll book's printed and their name won't appear in the poll book, they should vote an affidavit. Or, see a judge to get a court order. As you got closer to election day, it was more see a judge, get a court order, because there was only so much you can do. Try to get a court order. So we tried to do all that kind of work up to that period of time. We did talk to many people. And I think we had cooperation from a lot of the boards, even the city, with the volumes they were having, to look up the specific record and try and provide that to the voter. I would have never registered, not in that party, but if you look at the voter history, on many that I looked up, they voted in every general election, never a primary, but they're not in a party. But they claim to be enrolled in a party, because that's probably how they voted when they made their selections in the general election. But there was no record, and when you look at the buff card, 3 times they checked no party. And it was things like that, so we would give them the record. They would still argue with us, but that's their signature and their check mark next to it. But there were, you had to look each one up, because there were times where the board missed a change that was timely. And they made that correction. They told the person to vote an affidavit and that they would count it. So I can't, that's why you have to look up every one, because some people are right, some people are wrong. All we can do is get them an answer.
Okay. All right, thank you. Our next report is from ITU. I notice there's no one here from there. Are you guys gonna, Bob and Todd,
Certainly, we had a discussion at the last meeting of the rollout of the changes to the Nysboe system. We did not make that rollout for a number of reasons. Mostly, we were not comfortable that it was ready yet, and it's not ready yet. So when we will come up with a new estimated time once we are comfortable that it's ready. I don't foresee that in the very near future because of the other elections that we're also dealing with. From that perspective, we have submitted requests for some of the temporary help that we have money in the budget to pay for both the Nysboe and the bigger issue is the enhancements to the campaign finance and the candidate management system to get more temporary help in the building. Now that we're very far along in the development of the business rules, it's the time to develop, based on the business rules, what we want the systems to do. So we have different pots of money. The pots of money that are through the State Information Technology Office, temporary help has to be applied through them, out of their pot of money. The pot of money that's in our budget for contractual for the technology, the Office of General Services handles that. We had a conference call with them. We have submitted those documents to them. We're just waiting for a couple of the other items to get approvals on them. It's that old technology PTP, which I forget what the acronym stands for, but it's
Plan to procure.
It's a technology-related approval that doesn't take long, but it's just to get those help. So those will be the temporary helpers in the building to help build the system and make sure our people can run them when they're done. So we're moving forward on those issues. Certainly, the IT department was very busy with the election night results coming in. There were a lot of unique things in this cycle that we had to accommodate. The biggest issue, I think, is the special elections. Getting the numbers to make sure that we're not reporting inaccurately, from those systems, and so because we had 4 special elections and the presidential on the same day, and we had candidates withdraw up till, Monday, we were still able to accommodate it. So I think they did a great job in that area to help us. I'm not sure if we have anything else, Todd.
No, I think that covers it, Bob.
Okay. Any questions on that topic? Okay, then our last unit report is from Risa Sugarman. Risa?
Thank you, Commissioners. As everyone has said, we were very busy on primary day. I was at my computer all day answering questions. When Bob was out, I answered those emails. We had referred them to Bob and Todd for them to answer before primary day, but we helped, and my secretary was on the phone for the weeks before answering questions, as was the rest of the staff. Some of the questions that were in addition to registration on primary day and before were the hours of the voting. But on primary day, I got questions about time off for voting, which I answered with the help of Todd. He helped me out with the statute, so gave that to voters. Them with their employees, giving them time off to vote. Obviously, that was more for people out of New York City who had, or the counties that didn't have from 6 in the morning to 9 at night, that had the noon to 9 voting. In addition, some of the questions or complaints that I got were for access to the polls for people with disabilities, that it was difficult for some people to have access to the polling places. So those are complaints that we got, a couple of them mostly in New York City, having access, being able to get into the polling place to vote. It's been a little busy for me in the last week. Other than that, that's my report.
Okay. Any questions? Okay, right, that completes the unit reports, the unit updates for today. So we'll move on to old business. And our first item under old business is the FOIL guidance document, which I know Brian's worked on. I believe Kim maybe's worked on as well. But anyway, Brian, do you want to talk to this, speak to this?
Very, very briefly, Commissioner, and certainly we're available to answer any questions the commissioners may have. This issue has been evolving on the agenda for quite some time, and this is a consensus draft that attempts to take and pull together various relevant sections of the election law that are on the topic of voter registration and records access, and to place the information in a format which is more useful to commissioners at local boards of elections who are making determinations on making these records available. And so it is a compilation of those provisions, and basically runs through in a stepwise fashion, from a general rule to various exceptions, how to uniformly apply request for access to those records.
And we call this now guidance on access to copies of voter registration records. This is intended for the county boards of elections, is that correct?
It is intended for county boards of elections.
I move the adoption of the resolution.
I second. All in favor?
Aye.
Opposed? All right, it's adopted. Our next item is the resolution on the amendments to the independent expenditure regulations. I believe these have been out for public comment for some time. And these are now, as I understand it, coming back to us for final approval. I guess my first question is whether we received comments on our initial draft, and if we did we address them?
Well, Commissioner, we did receive one comment from Common Cause that was generally favorable. They did raise one technical issue concerning the identification of whether the candidates were being supported or opposed by the independent expenditure. Just a couple of things to address that. Firstly, the regulation and the statute currently require that when they file their weekly and 24-hour reports relative to their IEs, that they have to identify the office and district relative to the expenditure, and they also have to identify the clearly identified candidate in that filing. In addition, on the registration documents, the committees will identify those candidates that they're supporting or opposing. And then, in the context of this round of regulation, we have created a new form, which is a CFO 6, which is a notice of intent to engage in independent expenditures. And on that form, whether it's an IE committee or a PAC, they will identify the candidates that they're supporting or opposing through their independent expenditures. So we believe that through the process we capture that both statutorily and through the regulation. The new system that we're presently developing will have more robust features relative to disclosure of that information, but as it stands now, we believe that under our current system we do capture that information.
Okay, and as I understand it, these changes that we're adopting basically are reflecting the statutory changes that were made to the independent expenditure process last year by the legislature?
Correct.
Okay. Any questions on this topic for anybody?
Before we vote on this, I just want to clarify that this is the initial regulations which we're promulgating because there's consensus, and that we're continuing to work up a more detailed draft, right, of additional regulations that will provide clarifications and safe harbors.
Correct. That's my understanding as well. Okay, is there a motion to adopt this set of regulations?
So moved.
Second. Second. All in favor?
Aye.
Opposed? They are adopted. And then our last item is a discussion item, as it's identified here. It's on the political clubs. I know that there's been some training. I believe at our last meeting, we were informed there was some training that went on political clubs, and I don't know how that went, but I don't know if there's more to report on that.
I guess I'll start. Commissioner Kellner had provided a series of questions on political clubs, and I prior to the last board meeting drafted some answers to those questions, involving essentially what is it that well, the specific questions, for example, are, is a club required to file if it never receives or expends any money in connection with an election? And there was a series of other questions that were in the vein of trying to capture the basis for what we need to agree on to give good advice to people on how to know when they have to file, and what kind of activities bring them into that orbit, and what the statutory basis for all of that is. Bill drafted a set of responses to the same questions just recently. The answers are the same, but how we get to some of them are different. What is clear to me is that we have provided answers that, if read by a lawyer who has some knowledge of what's going on in the election law, we've done something good. But what we have not yet accomplished, and in the interval since the last meeting, we have just not gotten to it, is we need to, as Commissioner Kellner made very clear at the last meeting, have a tool that is decipherable by people who are having to make the practical decisions of what am I doing in my neighborhood with my people who agree with me and in my political club, and what of these things that I'm doing might make me have to have a filing requirement with the State Board of Elections. And so while there's some differences in how the approach is to the questions. It seems that in the final estimation, the answers are not necessarily so difficult to communicate if we make a list of the kinds of specific activities that would require filing, and the list of activities that would not cause someone to have a filing obligation. And in this process, and it's been very instructive to me, and I think also to Bill and Kim, is we've had an opportunity to really review the 40 years of opinion history that the board has, and on several occasions from different angles, the issue of can I do this or can I not do this, and if I do it, do I have to report and file, has come up in numerous different contexts. And I think that as we continue to move through this process, we should be able to produce a guidance document that will be decipherable by people who are actually using, who have obligations under the law, and we can help. But we are not there yet.
A lot of this also is not only the comments by Commissioner Kellner, but your experience in the training programs, correct?
Right. The two trainings for clubs in New York City and Long Island clearly indicated that there's some confusion out there in the world. I think we did an excellent job representing the board, our staff, obviously, in making sure that everybody who attended those trainings got the answers to the questions that they posed. And it was enlightening to see how their struggle unfolded and the kinds of issues that they have. And that will also be invaluable in enlightening a guidance document from us to help meet their needs and provide clarity in an area where there is admittedly all the way around a lot of statutory complexity. But if we move away from the statutory language and we look at the end activities of the entities and say these end activities, these actual on-the-ground activities will require you to file, and these other activities do not, I think we can provide meaningful guidance that is simple and comprehensible to the public. And we need to do that.
Yeah, I mean, I would suggest that goal goes beyond political clubs. You know, that's something we should be trying to achieve for anybody out in the community who's engaged in anything that relates to a campaign or a political party or a political activity, that they should be getting guidance that they can understand. Because I agree, it's not useful to repeat the statute to them if the statute is not clear. I think it's our job to clarify it so people have a common sense, because these are not lawyers a lot that work in this field, so to suggest that they can read the statute and understand what they have to do is not realistic. So again, I would just urge you that this goes beyond the clubs. This goes to any political committee or so-called political committee to understand what their obligations are. So I think that's a goal we should try to achieve generally. Now, would we have more training scheduled this year?
Yes,
And when will that begin?
they've already begun.
They've already begun.
Right, they run.
Regular trainings?
Yeah, just regular.
Yeah,
Regular, yes, regular trainings, correct.
And so you find that in the political club world, there are unique types of questions that arise that you don't see in the other training sessions that you conduct?
Well, clearly, when you have committees that are a candidate committee or a PAC,
They're more
or
clear.
political party committees,
Right.
they engage in very particularized activity that make it clear that they have an obligation to file and disclose that activity. Where you have some of these other entities, because if you even read the definition of political committee, there's some carve-outs where you're talking about political issues, et cetera, where they don't necessarily rise to being a matter that would require some closure. And where do you delineate that, and how do you advise people that they may have crossed the threshold, et cetera? So for these clubs or other organizations, it's just an issue of have they crossed that line or not? And what activities, as Brian alluded to, what activities can you engage in, or if you do engage in, does that put you over the line or not? And oftentimes there's a combination. Unfortunately, you know, a lot of these things blend.
So the issue there isn't really, what do I have to do to file? It's do I have to file?
Absolutely, that is the linchpin issue in that regard.
Okay. So what is your expectation as far as getting something together that would be in this form you're suggesting of easily understood?
My, Commissioner, I think it is very helpful to hold it over on the agenda. Short of issues that would get in the way, I think that we should be able to accomplish that by the next meeting. In fact, certainly it would have been our intention to have that happen for this meeting, but for the intervening ballot access filings, the lawsuits, and an election. But I think just holding it over for another month would be a recommended course that should get us to where we need to be to further the discussion. And it is a really important threshold issue on what is it that makes the obligation to have to file that. I mean, while it is certainly very applicable to clubs, over the years, it has occupied a significant amount of the opinion activity of the board, particularly in the 1970s. And there are implications for other types of entities. So a distillation of that body of law in a comprehensible manner, I think would be very useful.
Okay, then we'll expect something at the next meeting, so we'll hold it over till then. Any other questions? Okay. That completes the old business section of the agenda. The next item is new business, and the first item is petition rulings. And I believe we have a report here. This is the staff report on the both prima facie reviews and those that were specification objections. And I have a list of findings of the staff through a hearing officer process on each one of the petitions. Are there any, does anyone want to present something, or are there questions, or I have the report, I think all the commissioners have the report, I guess I could handle it either, if somebody wants to make
I'll
a,
move the adoption of the report. And if, Mr. Champoli, did you want to speak to any of these?
I have two that I'd like to speak to.
Are they up now?
I don't know, are they?
Yeah, I believe so.
I believe they're on the included in the report.
If I may?
Sure.
On the Independence Party petition in the 3rd Congressional District, we believe that the board should reject.
Just one second, John, that's the second page.
Independence Party petition, 3rd Congressional District.
Correct.
I believe he's talking.
Candidate?
Candidate Jack Martins.
Okay.
Okay, we believe that the specifications that were perfected should in fact be rejected by the board. The board received the specifications without proof of service. Within 48 hours, a letter came in.
I'm sorry, can I
Talking
just stop
about
you for a minute?
the
I'm,
second set.
okay, because I'm seeing two
Second
different
set.
sets of objections.
Not the valid petition, the one
Right,
where it's
it's,
deemed invalid.
Okay, I'm sorry. Okay, go ahead.
The letter specified no objector whose objections the proof of service related to.
Let me go grab the file.
Okay.
Maybe we need to see it in order to understand what you're talking about. Is that fair to say?
Well,
I'm
I'll grab
not-
it just
I'm
in
not-
case.
I'm not
I'll
quite
grab it
clear
just
what
in
you're
case.
saying.
They're all in the cart,
Yeah,
so
I got
in
it.
congressional order.
Let's just hang on a minute, John.
Okay.
Might be easier if we
It's
looked at
easier
it.
with the, it's
Yep.
easier with the documents.
Yep. You said you have two?
Two. I can go on to,
Do we need the documents for the other one as well?
no,
Well, then why don't you speak to that one?
on the same congressional district, 3rd, the objections to the Beddoe petition, they were ruled out,
I'm sorry, which party?
Republican.
Republican.
On the last page.
Okay, so, all right, so Beddoe,
And I believe your
3rd, got it.
the recommendation is to invalidate. I'd just like the board to note for its records that the hearing officer was kind enough to allow the respondent to recess the hearing, to allow the respondent to present the defense. We never heard from the respondent thereafter. And I'd like that noted in the board's records, because there is pending litigation, and I think it'll be relevant in that litigation.
Okay, so you're not challenging this, you just
No.
wanna make that statement? Okay. All right, then we'll move on to the other one, when,
I was the hearing officer there, and it is noted in the record. They didn't provide anything at the end of the hearing, nor did they when we re-met on Tuesday, so
Okay.
that already has been taken care of.
okay,
Good.
all right, just wait a minute for the
Okay.
file. Is there anybody else here on any of the, you guys aren't here on any of these other petitions, right?
You want to discuss our next
Casey,
meeting
I'd
date?
have- yeah.
While we're waiting?
Go ahead. I've got some, yeah, I've got some issues with June. Okay.
The only date we need you to firm up, that is a real date that we need, is August 8th.
Hold on a second, let me just get that in here. Well, let's one thing at a time.
Hannah,
August 8th is a day we have to meet, is that what you're saying?
well, that is the
That day
date we
or
need.
around that day?
That's the date we need to certify for the September primary.
Okay, so probably first week of August, or should we meet on the 8th? Doesn't matter.
Well, if we,
Well, we can talk about that. Do you need to talk about that now? Let's talk about June.
Oh,
Or do you want to do
No,
August?
I agree. If we're going to meet the first week of August, then we should meet towards the end of June as our
Well,
next meeting.
I can't meet till last week.
Till the, so
Yeah, I could either meet the
27 or
first week of the
28?
last week.
Yeah, first week I can.
Okay, but those are,
something different.
Well, we
So
could-
that's why I said, this
Yeah,
this
that's
is the
the-
updated version.
that's the congressional
That's
primary.
the congressional.
Does that affect you?
No,
That's why I wanted to check with you. Yours is
except
not the
maybe we
same.
need to be in the field.
So
on
this is the letter you
that
gave us.
day.
We would
With your handwriting.
And they're going to be busy. They're going to be
Is that
busy.
true? Is that
That's the
true?
one from last night.
What about the
Yeah.
27th?
Oh, you got a new one
We could
today?
do the 27th or the 29th.
In response to his email, Todd wanted us to work it out. That's the one I talked to you about.
When it
Right,
was
so I'm
on
trying
the
to find
27th?
out, this is what they're voting on, and he's in court. So I want the correct one for
Okay,
Padot.
the 30th.
Okay,
Where is
Yeah,
it?
30th.
Is it in the folder?
All right, 30th. 30th it is.
We sent her up that other letter.
How-
Here, this is the one that'll go with Tom to the minutes.
No, it's what they have to vote on.
Right.
It's the same, it says 12:34. Is that the right number?
Correct.
The letter could be
Correct.
correct, but is that the right number?
the 26th, that's what, this
20, where, you
You will
did?
get Padot also to look
I got
at?
it right
For
here.
us, for us to meet?
Yeah, maybe I put it down the wrong.
I'm not aware of us doing
Have the
it.
right
Well, I'm
number.
happy now.
Okay.
June 30th?
30th of
Number
June.
25, I don't know if you're-
Well, so there's your proof of service,
Here's
right?
the proof of
No,
service.
he's number 25. He's
And what his
CT3.
argument is, I
know
believe,
how
is
you've got
that
them organized.
the specific objectors on whose behalf this was being filed was not clear based upon a case that he had. But later that same day, the gentleman, the lawyer, submitted this document specifying the objectors and included a copy
It's
of his
9:56
document.
now.
We accepted that as valid.
So he had a case that this is not sufficient?
Well, arguably, it was not sufficient because
Which
the,
one is right?
Board couldn't know what
Right.
spec that.
there was
Okay.
three objectors
certificate went
originally in
with.
this
Okay.
case, and one
Okay.
dropped out.
Okay.
And so you didn't know that the specs were being perfected on behalf
Gave
of
him one more
the two
out.
that we're
Right.
continuing
I think
on.
this is
Today.
writing it.
Okay.
And then
That's
the
12:34.
affirmation
What that
that
other-
he
Cleared
filed
that.
on
So
the
this
same
was
day,
correct.
cleared
That's
it
what I
up,
wanted to check.
and the
Okay.
gentleman signed
I need.
So
his
the
name
spec-
and
letter needs to be
submitted
fixed.
a
Hold
copy
that
of
one
the
out.
original document. They
Now, is
both were
this the
filed.
objector, or is that?
I think we
the
sent that
attorney?
letter up
The
this
attorney.
morning.
This is the
But-
attorney.
So he's doing it on
Just
behalf.
that
He's
you
just
have-
gonna mark what it
He's
should
arguing
be.
that an affirmation is not applicable because the CPLR says it's only in court. I happened to be in court with this yesterday. But on behalf, had it just said the objector came here in pencil, it would have been completely sufficient here. Do you have any other questions? Mr. Spanel?
Okay, you
Okay,
guys are okay.
all right.
I don't understand that.
Okay.
I can,
You can take those, I don't think we need them. All right, I'm gonna let him go. and then we'll- John, you wanna finish up then? We've looked at the documents, go ahead.
To go back to the timeline, the board received the specs with no proof of service. In 48 hours, you received a letter which had proof of service attached to it. However, that letter did not specify which objectors proof of service that was. And there were multiple objectors who perfected objections in that district on that petition. Subsequently, you got what purports to be an affirmation, which is handwritten, which does not have proof of service attached to it, saying, when I sent you the letter, this is whose proof of service,
Sorry, confused
these are the objectors whose proof of service were attached to that letter. Under
I'm sorry,
CPL
John, can I go back just a second? I am looking at that letter. It does have, there is a proof of service attached to that affirmation.
Not to
part of
the
it. Am I
affirmation,
wrong?
to the
No,
letter.
you are not wrong.
It's a photocopy of the letter.
Here's the letter.
And this proof of service up here.
It's a photocopy, it's not.
Oh, I see. It's not the
actual
original.
Photocopy of the original.
I got
that
you.
was
I see what you're saying.
Photocopy of the
Okay,
letter.
fair enough, John. I
We're
got you.
saying the same thing. Okay,
go ahead.
and the point is, that affirmation and anything attached to it is not an affirmation. Under 2106 of the CPLR, an affirmation may only be offered by an attorney in the context of a court proceeding. So what you have is a piece of paper that purports to be a sworn statement that is not a sworn statement. If it were an affidavit of service, and it was sworn and it was notarized, I wouldn't have a problem. My problem is that that last handwritten piece of paper that you got is a nullity, it's nothing. And therefore, it does nothing to cure the defect in the letter which had the actual proof of service attached to it. Therefore, the board properly should have rejected the specifications, and that would leave the petition valid.
So you're saying, John, if I understand your position, that you would accept an affidavit of service being
Correct.
filed by the attorney of record, but you will not accept an affirmation by that same attorney?
There was no attorney of record at that time. There's no caption, there's no index number on that affirmation. It does not relate to any case that was pending.
Well, let me understand something though. If this individual attorney who filed the affirmation had filed an affidavit of service instead of the affirmation,
That would
accept
be
that.
sufficient.
Okay, so the affidavit would be, the affirmation would not be.
That, because it's not an affirmation, is what I'm saying. By the tech, in the context of the CPLR, which grants an attorney the power to issue a sworn statement without it being notarized, without it being sworn to, that is not an affirmation. Does it meet the definition under the CPLR?
Because,
There was no lawsuit pending.
okay, because it's not done in
And
the
it's
context
not-
of a court
It does
proceeding.
not carry the caption, the index number, or state that it relates to
Okay.
a court case. And it wasn't offered, and would have to be offered in the context of that court case. So an affirmation of service that I served in order to show cause is permissible.
Right.
But an affirmation of service here at an administrative agency, I don't have the power under the law to issue the affirmation. So it's a nullity, it's not an affirmation. The CPL law doesn't provide for it in administrative proceedings, only in court cases.
Okay. Any more questions of the commissioners?
We don't require an affidavit, we just require proof of
Yeah,
service.
yeah. I mean, I guess it's that.
We just require proof of service, right?
Yes.
So the.
Proof
the
of
elec-
service is in
election
the
law-
statute.
Election law calls for us to.
Well,
have
it's our reg,
Our reg.
It's our reg.
our regulation.
For proof of service, which we do have.
Right, doesn't require an affidavit.
And right, wrong, or indifferent, the bottom line was when they did the count unfortunately was short. So it's a question of now you have the whole thing and you have a count that basically falls short of what is required. How do we at that point just go, well, wait a second, you know, there's a technicality here which we will try to hang our hat on. As much as I may love Jack Martin's, I just don't feel comfortable in, I've used the expression before, in trying to squeeze the toothpaste back into the tube. Once we know that that the filing is short of the required signatures, I don't know how we can overcome that.
Well, Commissioner, if I can respond to that, this would not be the first time this board has put a candidate that did not actually have the required number of signatures onto the ballot. I can personally attest to that.
But it would be the
Okay.
first time we rejected a specification on these grounds.
And we've
Well,
accepted
because,
photocopies of the
well,
proof of
how many
service, not
times
always
have you
just the
had
original.
an affirmation submitted to you as proof of
We don't
service?
even require an affirmation.
I
We've
understand
had
that.
less than that as
I
proof of
understand that, but the
service.
letter standing alone, if the affirmation is a nullity, okay,
I think
The
we
letter
hear you,
standing
but we
alone
were
is
able to,
insufficient.
all right.
Yeah, I think
We should.
I think we understand. Anything else?
All right, so I made my
Appreciate the
motion.
argument, John, but unfortunately, I think it falls a little short.
We have a motion by Commissioner Keller to adopt the report as submitted. Is there a second? Second. All in favor?
All right,
Opposed? Okay.
So for candidates listening to our webcast, the notice to candidates, if they are, will go out by overnight mail unless they have communicated to us earlier that they would accept it by email. And this will be done as soon as the meeting's over.
Okay, we have one more piece of business under new business. This is the guidance on, well, actually relating to the Hispanic Leadership Fund court case that was, the decision was rendered some time ago. I can't remember the exact date, some time ago. So this is a new piece of guidance that this board would put out to those seeking to follow the Hispanic Leadership Fund court case. Does anybody, Brian or Kim, do you want to, or Bill, do you want to speak to this, or do you have
Before
questions?
that, I don't have a copy of it in my packet.
sorry.
I've read it, but
You don't?
I don't, there it is. Okay, thank you.
Okay.
Oh, it's, okay, sorry.
Okay, I think, Bill,
Go
Bill,
ahead.
do you want to explain
Sorry.
this?
Sure.
Go ahead.
As the commissioners may recall, a couple of years ago, there was a bevy of lawsuits that occurred at the state and federal level that the board was
This is not-
party to.
Here.
And at that juncture, the board had issued some guidance concerning the application of the $150,000 aggregate contribution limit to individuals, and also as it related to that limit in relation to independent expenditure committees. At that time, when the board issued that guidance, this matter was pending. And so the issue of whether or not the aggregate $5,000 corporate limit would apply to corporations making contributions to independent expenditure committees would apply or not was still in flux. Subsequent to that, the court did render a decision in an as-applied context and ruled that as applied, this 501c4 corporation, Hispanic Leadership Fund, Inc., they found that, they ruled that the board was enjoined from enforcing the provisions of 14-116.2 against the plaintiffs, which were Hispanic Leadership Fund, Inc., and Freedom New York, which was the PAC, or the Independent Expenditure Committee more particularly, that would have received this contribution. And so this guidance document would simply state that as applied, and based in the context of the other litigation, that it would be unenforceable to say that in the case of Hispanic Leadership Funding, that they could make unlimited contributions to independent expenditure committees, but that any other corporation could not. So this merely takes the as applied in that very specific context and applies it across the board. And it closes that loop.
Now, we previously adopted an opinion. Why have we changed it to guidance statement as opposed to opinion?
That was not in the context of an opinion, that was merely a resolution that the board voted on in a board meeting. There was not an opinion that did that.
Yeah.
There was a resolution passed by the board, there was specific language that was read at the board, and the board then adopted that language, which then went into a guidance document that was issued to the public. So this does follow that format.
I think from us, where we have guidance first, is where do we put it out so public can see it? You know,
Well, is there a difference in, legal as to whether it's guidance or a formal opinion by this board? Is that?
I don't think.
The statute uses the word opinion in several places, but it doesn't use the word guidance.
I don't think it would be a problem if we changed the format. Make it an opinion. It's just we haven't had an outside request. This was a board-initiated process.
Yeah. I mean, I don't think that matters whether we, as to whether we do an opinion, whether we generate it or somebody else asked for it, but.
And I'm just thinking of, where it goes on the website. We publish opinions. The opinions are numbered by year.
No, I tend to agree, and
I would just suggest that we do the other one as well and perhaps put them together. The other resolution on the individual aggregate limit.
Make them both opinion.
And do this one. We could make them
It's a
both
single
opinions.
opinion.
Yeah.
would we want to adopt the guidance for this meeting, and then we can turn it into an opinion in the future, or not the guidance now?
Sure.
That's okay.
Yeah, I don't
mean,
care.
I'm just talking about format here, that's all.
But I think it's more than format, Commissioner,
Right.
actually. I think it does rise to a different level when it achieves formal opinion status. To me,
Right.
guidance is a lesser standard than a formal opinion, so.
That's why I raise it.
No, I think that's a good
If I may
point.
interject, if the commissioners could adopt this as a guidance statement, such as we did the aggregate limit, then they would both be in the same format, and we can reference that when we convert them into the formal opinion status.
Yes.
Okay.
I'm okay with that.
Sounds good.
Thank you.
Besides the format, are there any other questions about the subject matter
Right.
text of the document in front of us? Or anything else you want to say, Bill, as far as explaining this? Okay.
I mean, the staff did work on this language and came to consensus on it.
And we did consult with the Attorney General, and the Attorney General has not raised any objection.
In particular, the Solicitor General's office, obviously, they're in charge of defending state statutes, and they were consulted initially in making the determination not to take an appeal to this case, and when they reviewed this, indicated that this was consistent with their view of the operative law.
Okay. Then I would entertain a motion to adopt this guidance. A motion, second?
Second.
All in favor?
Aye.
Opposed? And I guess we do that and also direct the staff to create a formal opinion that will adopt this plus the other guidance document related to this. Okay. Let's see. That is the end of the public meeting agenda.
Do we have a final date on the next meeting?
I'm sorry, yes, June 30.
30?
June 30 will be our next meeting. So, is there any other business to come before the board before we would entertain a motion to go into executive session?
And the executive session is for personnel.
That's my understanding, personnel.
There's no enforcement matters. Okay.
I'll entertain a motion to go into executive session for personnel.
So move.
Second?
Second.
All in favor?
Aye.
Opposed? And the public session meeting is adjourned, and we do not expect to come back into public session today.
Thank you.